I want to answer a very common question about filing for Social Security disability and SSI. That question is, what do I do if I'm denied? What are my appeal rights? Hello, I'm Janet Cox, attorney with Cox, Stansberry, and Kinsley. We're a law firm who handles personal injury, long-term disability, and Social Security disability and supplemental security income. When you file for Social Security disability, your case is decided by the Disability Determination Service, a state agency that has the contract with Social Security to make the first two decisions in the disability evaluation process. If the first decision in your case is a denial, you're not alone. Only about a third or less of the claims are approved at that level. Your denial decision will state your rights to appeal for a reconsideration. The reconsideration decision is made by DDS as well, but by examiners who have had no previous involvement in your case. If you're denied at recon, the next level of appeal takes you outside the jurisdiction of DDS and to the Office of Hearings Operations within the Social Security Administration. Your recon denial letter will inform you of your right to request a hearing before an administrative law judge or ALJ. Requesting a hearing is a very important step. You have a right to appear in person before the judge who will be deciding your case. However, currently there are choices for you to appear over video or by telephone. By the way, I have a separate video on choosing a telephone hearing, so you can check that out. Once you have chosen the type hearing you prefer, the hearing office will give you about a 75-day advance notice of the date and time of your hearing. At that time, you will be informed of the judge who has been assigned to your case. It's very important to know that the judges are not bound by prior denial decisions. They make what we call a de novo decision, which means they make an independent review of all the evidence and your testimony before reaching a decision. Now, unlike the decisions at the lower levels, the judge will prepare a detailed written decision explaining how he or she weighed the evidence, as well as set out how they reached their decision to approve or deny the case. If the judge denies a case, the next level of appeal is a request for review before the Appeals Council. They also work within the Office of Hearings Operations. The Appeals Council does not hold hearings. Rather, they review the judge's decision and will accept the request for review if they find an error of law or another compelling reason to reverse the judge, which is rare, or remand the case back to the judge to conduct another hearing to correct the errors or shortcomings they found. If the Appeals Council denies your request for review, the next step that can be taken is to file a complaint in federal district court. Again, there's no hearing for you to attend. The federal judge assigned to your case will review a transcript of the entire record and decide whether the judge's decision contains an error of law or whether the decision is based upon substantial evidence. Your attorney writes a brief or legal position in support of the appeal. Social Security's lawyers will file a response. After the attorneys have made their arguments, the federal judge issues a written decision. Now, this is interesting. If a federal district judge denies an appeal, the final two levels of appeal are the Circuit Court of Appeal and the U.S. Supreme Court. As you might imagine, few cases go to those levels. Those cases would involve new issues that have not been addressed already, constitutional issues, or perhaps involve interpretation or a challenge to a new law or regulation. Here's an important note. If you appeal to the Appeals Council, you cannot file a new application while you have an open case there. However, after the Appeal Council denies a request for review, you can start a new application and even continue on to federal court with your older case. Sometimes it's advisable not to go to federal court. Some cases have the merit to do both. And remember, you're not required to file an appeal even though you have the right to do so. Not every case has the merit to be won on appeal. Sometimes it's best to file a new application. Here's where a very experienced attorney can provide the right guidance for you to make the best decisions. But now to recap, decisions made at the lowest levels in the process are the initial and the reconsideration decisions made at DDS. After that, a case would go to the Office of Hearings Operations for a hearing with an administrative law judge, and after that, the Appeals Council. The next step is federal court, U.S. District Court. One final but very important note. The appeal deadline for all of these steps is 60 days from the date you receive the denial decision. Now, Social Security allows 5 days for the mail to be delivered, so you automatically have 65 days from the date on the decision. If you miss the deadline, You may be allowed to proceed if you have good cause for late filing. Thanks for listening. If you're applying or thinking about applying for SSDI or you have already been denied, reach out to Cox, Stansberry, and Kinsley for a free consultation. If you found this video helpful, give it a like, subscribe, and check out our other videos. We cover topics such as what is SSI, what to do in a hearing in front of an administrative law judge, and more to help you through this process. Thank you.